The provisional waiver process sounds too good to be true to a lot of people because you get to stay in the United States while your waiver is pending. And hopefully, if everything goes well, you won't be outside of the United States for very long once it's approved. But there are some negatives to filing a provisional waiver, as well as some positives. So we're going to go through both of those today, and then hopefully that'll help you make a more informed decision as to whether this is the correct route for you. The positives, yes, you get to stay in the United States with your spouse while the waiver is pending. Another positive, if your case gets denied, you can file it again. Negative, if you have to file your case again, the odds of it being approved are very slight, especially if you're using the exact same arguments, if immigration didn't find them convincing the first time around. Plus, if you wait for a long time to refile, you may have some passage of time to come up with some better arguments or something more persuasive. But the longer you wait, remember, even filing the provisional waiver doesn't place you in valid immigration status. So if you keep filing one after another and after another, technically you can do so, but ICE can also pick you up at any time. There is no protection by just filing an I-601A. There's also no work permit. There's no way to legalize your status while filing an I-601A. So if you have been under the radar for many, many years, you need to think about exposing yourself to immigration further, whether this is worth you filing the I-601A now or waiting until you have a lot better documentation to do so. Because remember, if you have to refile the case, then they're going to look at all the arguments and all the evidence that you gave them before. So if you're just making the same arguments and just giving them the same evidence, this is not really going to buy you time. Okay? And immigration is going to be very annoyed with you just giving them the same documents over and over again, and will summarily dismiss your case, and it won't gain you any favor, especially if you have to eventually travel abroad and do a traditional 601 hoping for a different result, because traditional 601s go to a different agency within CIS, a different service center. So just be very careful. You sometimes get pigeonholed in a weak case, and you have to explain why that evidence is no longer valid, or it's changed, or the circumstances have changed. So it's best to put your best foot forward initially, period. And just because a 601A is available doesn't mean you should apply for it if your case is not strong. There may be other options available to you. And you also need to think about how your history could affect whether or not the I-601A is approved. If immigration has reason to believe that you have triggered other grounds of inadmissibility besides unlawful presence, your case will be put on hold and potentially denied. They only decide unlawful presence I-601As. If they believe that you have a criminal act that will make you inadmissible and you would need a 212H or a criminal waiver, if they believe that you lied to get into the country or lied to an immigration officer, then that is a reason to believe, and your case could very well be denied. So there is risk about going forward if you're not absolutely clear and have this strong persuasive evidence that you don't have any other grounds of inadmissibility. There is also a potential advantage to the 601A right now as opposed to doing a traditional 601, besides being able to stay in the United States temporarily while it's pending. For processing times, the National Benefits Center is the one that decides the I-601As. For traditional I-601s, for all types of 10-year bar, criminal bars, prostitution, misrepresentation, those are decided by the Nebraska Service Center. Those cases right now are taking about 7 months, whereas non-traditional, the I-601A provisional waivers just for unlawful presence, are taking about half of that period of time. So you could have resolution a lot faster, but it may not be your best, most persuasive case if there's any other ground of inadmissibility that could possibly be triggered. It could take just as long as the traditional. So there's a lot of negatives and positives with the provisional waiver process. You need to have your case thoroughly vetted with a competent immigration attorney who knows the difference between these types of waivers and can recommend to you, looking at your life, looking at your history, which one is more likely to succeed. I am an expert in complex family-based immigration cases and have a 98% approval rate for the past 12 years. I am a nationally published immigration author and frequent public speaker on immigration topics. I regularly train other immigration lawyers on complicated marriage and family immigration cases for the American Immigration Lawyers Association, Federal Bar Association, and national legal education providers. I represent clients all over the U.S., traveling to immigration interviews and deportation proceedings. Visit our website, humanrightsattorney.com, for more in-depth information and articles on complex family immigration issues.